Hi, good afternoon, everyone. Welcome to today's program, Legal Abuse as a Continuation of Coercive Control, featuring Professor Ellie Gutowski. I'm Jane Stover, and on behalf of the UCI Initiative to End Family Violence, I want to welcome you and thank you for joining our first program here in the 2024 through 25 Speakers Series. The UCI Initiative to End Family Violence unites faculty from 21 different departments and 11 schools across UCI with community partners in interdisciplinary research, education, and clinical interventions in abuse. In addition to directing the initiative here at UCI, I'm also a law professor. I direct our domestic violence clinic. Our law students, under close faculty supervision, represent abuse survivors in a range of civil, immigration, and policy matters. And I mention this because we see just how often, even after survivors are able to exit an abusive relationship, the courtroom then becomes the new arena for control. And we see how our clients struggle to protect their children through court. And Professor Gutowski's work just so clearly names and validates the legal abuse that so many of our own clients have experienced. I've relied on her research both in my own scholarship and in client representation, and I'm so glad that she's here with us, sharing with our broader audience today about this issue of legal abuse, or abusive partners' use of court processes to enact coercive control, which has been a really overlooked but common way that survivors and their children are harmed during the family court process. And we see how legal institutions really end up then being gatekeepers to safety. To further introduce Dr. Gutowski, I'll mention that she's a registered psychologist and assistant professor at the University of Toronto in the Department of Applied Psychology and Human Development and at the Ontario Institute for Studies in Education. Her research really focuses on intimate partner violence, especially on how systems-level responses can either promote well-being or unintentionally cause harm, and how providers and systems can be more trauma-informed and anti-oppressive. She received her PhD from Boston College and worked closely with Dr. Lisa Goodman, who's spoken with our center before. She completed a clinical fellowship at Harvard Medical School and a doctoral residency at Emory School of Medicine. She's received so many grants and awards for her research and is truly making such an impact. So please join me in welcoming Professor Ellen Gutowski. Thanks, Ellie.
Thank you so much for having me. I'm so excited to talk with your group. I'm just going to share my slides. So I'll be talking today about some of my work on legal abuse as a continuation of coercive control. So I'm up here at University of Toronto, so I'm up in Canada. But I will say that the research that I'm presenting today, I conducted in the United States. I'm also a psychologist and a researcher. So I'll share, I'm not a legal professional, but I can talk to you about the research that I've done, and I have the perspective as a psychologist. So I actually first got interested in this topic as a graduate student. I was working with Lisa Goodman, and she connected me with a group of survivors who had been through family court processes and had sought custody of their children through these processes. And part of this group was also interdisciplinary professionals, so family court attorneys, domestic violence advocates, and social workers. And I learned through them about the family law system. As a psychology PhD student, this was something that I was just learning about. And I actually did a qualitative study as a result of my collaboration with this group and with Dr. Goodman. And I learned just how difficult the experience was for many survivors to go through family court. They talked about how the legal process was associated with increased trauma. One shared, it's the one thing left that really triggers my trauma. Another survivor who had been through this process shared with me that this is added suffering in addition to the prior abuse that she experienced. And I also remember the story that one survivor shared with me, that even though her court process was about 2 decades ago, she still hadn't changed her name because she couldn't bear to go into the courthouse. She said it was traumatizing. So to hear about these stories and just the emotional and psychological difficulties that survivors had to go through when going through family court processes during this very difficult time of leaving an abusive partner, I was wondering, as someone who is a researcher, what can I do? How can I further knowledge of this issue? So we learned through this paper that survivors named a lot of different aspects of the court environment and the system that they felt needed to be addressed. But one particular point stuck out to me. Many felt that coercive control played out in their legal processes, but that this was not identified by the courts. One shared that the courts really need to start identifying coercive control. She said that's been an incredible component. It shouldn't be tolerated in a court of law. It has no place in a court of law. So I was really inspired by these stories that I heard, and also by this problem that existed, right? That coercive control seemed to be playing out through legal processes, but the survivors I spoke to in my research felt that it was not identified. So today I'll talk about coercive control. I know this is probably not new information for many of you, and I'll talk about it from an empirical and theoretical perspective. So as a researcher, I can kind of talk about the scholarly literature on this topic, although I know that there are very legal definitions of this. I'll also talk about legal abuse and some of my research on this, including my attempts to develop a measure of legal abuse, so a quantitative measure that helps us capture this phenomenon. I'll talk about some of my work on the correlates of legal abuse, as well as what some of my studies show about how judges respond. Finally, I'll end with some considerations about what could help survivors who are going through such a difficult system and process. Okay. So coercive control, according to scholarly definitions, is thought to be a repeated and ongoing pattern of behavior in which one party attempts to gain power and control over another. It's not always physical or sexual violence, and it can lead to behavior that can be really difficult for those who are outside of the relationship to understand. So Evan Stark is one of the original authors who writes about this abuse dynamic. And in his book that he published in the mid to late 2000s, he writes about an example of a husband and wife who are out at a social gathering. The husband hands his wife a long sleeve shirt, and the wife starts panicking, right? And so for an outsider, seeing this even loving gesture and this panicked response would seem kind of irrational, right? Why would the wife in this situation be having a panic attack in response to being handed a long sleeve shirt? But Evan Stark goes on to write that if we knew the dynamics of this relationship and we knew the existing coercive control dynamic, we would understand that this gesture is not an act of caring, it's actually a threat. What the husband was communicating was, I'm going to beat you so badly that you're going to need to cover your arms, right? And we could only know that if we fully understood the context of the relationship. So I share this example to just illustrate how coercive control dynamics can be very subtle and difficult to detect for those of us who are outside of a relationship. Dutton and Lisa Goodman also published an article, a theoretical article on coercion in relationships that I find really helpful, where they talk about how coercive control often entails demands paired with credible threats for non-compliance. So the person who uses this form of abuse really creates the expectation that there will be negative consequences for not complying with demands. Right? So this might be a history of episodes of violence in the relationship, or talking about being violent to others outside of the relationship. Partners who use this form of control can also create and exploit vulnerabilities. So, for example, causing a survivor to lose their job and become financially dependent. They can socially isolate partners, and this can also create further vulnerability to abuse. They can engage in surveillance, right? So constant monitoring, and this can be direct, maybe installing video cameras in the home or calling multiple times a day, or it can be indirect. So, for example, requiring children to report on their parents' behavior, or enlisting friends or neighbors in, asking, saying, my partner's unwell, did they leave the house today, right? Asking them to report on their partners. What's really important to this dynamic is differences in social power, because coercive control inherently involves one party leveraging their social power over another. And so the identities of the people in the relationship, as well as their sources of power, is really crucial to how abuse manifests, how it's experienced, but also how people outside the relationship respond. So Evan Stark, for example, writes extensively about coercive control in heterosexual relationships, and writes about how often, because of gendered power differentials, this can be a gendered phenomenon, where a lot of times women are targeted with this form of abuse. Okay. We also know that, there's some research on immigration status being used. When one party is undocumented and another partner is a citizen, for example, there's a power differential based on immigration status that can make it hard for the undocumented partner to seek help, just as another example of a source of power. Right? So we know from some research among same-sex couples that power imbalances is also crucial when we're identifying coercive control dynamics in same-sex partnerships as well. As you can imagine, and many of you I'm sure know, separating from someone who uses this form of abuse can be really challenging. It can also be associated with an escalated risk of violence and homicide. And this is especially challenging for parents who really have to think about their safety and access to resources, but also safety and access to resources for their children. We also know that many parents end up in a courtroom like this one to deal with matters like divorce, child custody, visitation, child support, division of assets, right? But it's in this context that a coercive control can be continued, right? And so this can happen through legal abuse. So Lisa Goodman and I, in the paper we published just last year, defined legal abuse as an enactment of coercive control through the legal process. And we're definitely not the first ones to write about this. There has been a good amount of qualitative research published on this issue from Australia, New Zealand, the UK, across North America, so from many places around the world, really observing how legal abuse can play out, especially in family law processes, right? So it can play out through things like threatening or attempting to take custody of the children, threatening or attempting to get unsafe access to children, using in-person proceedings to cause distress. When I first started doing research on this topic and I interviewed survivors who were involved in family court cases with partners who were abusive and used this form of abuse, I remember being shocked to learn that after leaving an abusive relationship, survivors were still involved in litigation 10 years or longer, It can also involve things like distorting information or lying to discredit, for example, the other parent's parenting ability, or through financial harm, right? By threatening or maybe withholding financial support. This might be in the form of child support, medical expenses for children, threatening or actually attempting to take shared assets as well through the court process. So Lisa Goodman and I were interested and seeing if we could establish a quantitative measure of this issue to really define this topic. And we were interested specifically in the question of how do we define and measure legal abuse? We know that this is something that so many survivors who we've spoken to are experiencing, and are experiencing as quite distressing. How do we define and measure this phenomenon? So we went through the whole process that is recommended for measure development, where we looked at the existing literature. We drew from the qualitative interviews that I had conducted earlier with survivors who had been involved in family court, and really looked at what they had to say about their experiences. And then we consulted with 23 experts, and these were academics and scholars, as well as practitioners across disciplines. So legal disciplines, social sciences, social work, domestic violence advocates, and also survivors with lived experience who had been through family court and experienced legal abuse firsthand. So we went through all the stages recommended for measure development, like piloting these items. We were able to translate them into Spanish as well. And we had over 200 family court involved survivors who were mothers from all different regions of the United States respond to these items in a survey format. We then were able to do a factor analysis in order to establish the validity of the measure. And this landed us with a 14-item self-report measure of legal abuse. We found that this measure, when we looked at the kind of statistics, and we were able to test whether there was a correlation between legal abuse experiences as reported on this measure, we found that these experiences were correlated with other forms of abuse. So some example items are, we asked survivors to report, did the other parent in your legal case threaten to use the court to punish you, or threaten to withhold financial support, just as some examples of the items on this measure. And I know this is very small font, but this is what the final measure looks like. So it's these 14 items, and it's really meant for the person who is targeted with legal abuse to be able to fill this out and report on their experiences in the legal case with the other parent. So I want to name also that every piece of research has limitations, right? And so when we're developing new measures, there's always more we can do to study, and refine these measures. So for example, it's usually good to test measures across multiple samples to see if the factor structure holds up. So this is kind of our initial publication with this measure, but I'm hoping that it will be refined and improved upon. I also want to note that earlier I described the importance of really understanding the context when we're assessing for coercive control and really understanding power differentials. So, understanding context and power, those are issues that might not come through on any quantitative self-report measure, right? So this is really not intended to be a standalone assessment tool, but it's meant to be a first attempt to define and name what this phenomenon is so that we can do further research on it. And so it might augment a process of assessing that is also informed by interviews, by gathering third-party information, and doing other rigorous assessment. Okay, so we were able to, once we developed this measure, we were able to do some quantitative research and understand whether experiences with legal abuse were associated with other kinds of experiences like mental health. So we were interested specifically as psychologists, and based on what survivors were reporting to us in the qualitative interviews we did, what the mental health correlates of legal abuse were. And we found, when we were able to look at survey data, we found that legal abuse experiences were actually associated with having more symptoms of post-traumatic stress disorder, as well as more symptoms of depression. And so these associations held even when we statistically controlled for other experiences of abuse in the relationship. So legal abuse seemed to independently be associated with these mental health symptoms. Okay. We also found in some of our research that how judges respond to abuse really matters, right? We found that judges' responses, looking at this quantitatively, were associated with symptoms of post-traumatic stress disorder and depression, right? And so how judges respond really did seem to be associated with survivors' mental health. And in qualitative research, how survivors describe their recovery after leaving abusive relationships. For example, one survivor who I interviewed talked about, I kind of felt like I was spoken to by the judge as if I was stupid, because why didn't I just leave? I mean, don't you know any better, right? So she was experiencing something called judicial betrayal, right? So feeling like you go into a system, you're dependent on the system for to recognize the abuse and to respond in a way that is just and creates protection and safety. And she felt instead that she was, mistreated and disrespected, or feeling like the abuse is missed can also be a way of experiencing judicial betrayal. In other qualitative research we did, survivors talked about positive experiences with judges who recognized the abuse. One shared, "My ex-partner never punched or hit me. He beat up my feelings of self-worth and tore me down day by day until I finally broke free. I truly believe the judges saw that. Their treatment towards me in court was amazing," right? So you can see the differences in these narratives when abuse is recognized and when it's not. In other research, we asked survivors what helps, right? So as psychologists, we were really concerned about just how psychologically distressing this process could be, right? So we were interested in how is it that survivors cope, right? What helps? Something that came through across many participants who we surveyed is that being supported and being believed and validated during this process was really crucial. It was best if this could happen in court, right? So a judge who believes and validates, but some also spoke about receiving these experiences from outside of court. Others spoke about the importance of having help managing family life after separation, and co-parenting with someone who abused them was really, really stressful. And being given adequate support was really crucial. For example, one person shared, "The biggest help has been no longer having to interact with my abuser to co-parent since he finally is not allowed to see our daughter." So having that protection was very, very instrumental to recovery for this person. Many described ways in which they had to cope and adapt. Many described having to educate themselves about family court, having to learn about domestic violence, having to kind of modulate their expression of emotions in court, even when really upset and really angry, having to kind of present a certain facade to the judge so that they'd be taken seriously. But I also want to acknowledge that a sizable proportion of participants who I've surveyed have also talked about this experience of feeling betrayed by the system. So a sizable number of people who have participated in our research have conveyed this sentiment that really nothing has helped, right? So this participant shares, "Nothing has helped, absolutely nothing. No one has really been willing to help, and everyone wants insane amounts of money. I believed in justice before this. Now I realize that the court system is nothing more than a source of income, and politics, it's a business." So I want to end by acknowledging that sentiment of betrayal, and that many survivors have reported to us throughout our research. And hopefully this is something that with some change and additional education, we can address. So to take away from this, from this collection of work, I think we've demonstrated that legal abuse is a harmful form of coercive control. Of course, there's a need for ongoing research on this topic, and especially a need for ongoing quantitative research and efforts to refine the measure of legal abuse. Survivors report that validation and support is helpful, right, inside and outside of court, but not enough, right? That there's a need for protection, for help with managing the challenges of maybe co-parenting with someone who abused you and abused your children, and some protection. There's also a need for ongoing training on coercive control. So you can see the differences in how survivors reported their experiences of having their abuse experiences kind of recognized versus not, right? So when they're not experienced, this can be associated with worsened mental health. So that's what I prepared, but I'm hoping that we can engage in some questions as well, and I'm happy to talk more about any of these studies. I also want to acknowledge my co-authors and collaborators on this project, and those who gave funding to this work, community partners and consultants who really spent a lot of time and energy consulting, but especially the survivors who participated in my research in hopes of helping someone else.
Ellie, thank you so much for the incredible information that you shared with us, and in really such a thoughtful, sensitive way that honors survivors' lived experiences and real struggles for safety. And when you mention, judicial betrayal, we think about institutional betrayal that we've had sessions on before, in terms of just this awareness of what are an individual's expectations
Yes.
of justice and safety. I've had clients certainly who have said, well, I told my daughter that she wouldn't have to see her father
Right,
again after this abuse.
right, right.
Our family court system, it's seeing your slide about the survivor reporting, well, we no longer have to have contact with the abusive
Yes,
partner, is pretty rare.
yes,
And so we think about, how do we make visitation as safe as possible? How do we and how do we keep that safety sustained over time, so there's not just an increased opening of access when it's not safe.
absolutely, absolutely. Thank you. And I also want to, note that that's not necessarily what every person I spoke to wanted, right? I think that that was a helpful outcome for that one participant. But some people do want to safely manage, visitation and other kinds of parenting arrangements.
Yeah, no, that's so important. That's right. That's right. In terms of just the diversity of goals and what might be safe for an individual and fit their, yeah. Did you do justice today? Is what does that look like for an individual in terms of their own goals as well? Yeah, so we would invite anyone to be able to put any questions into the Q&A, and we're able to see those. And when I came upon Ellie's research, it was as I was doing research for an article that I have in the works that's focused on discovery abuse. And so this to me is really a subset of overall legal abuse, and an example, a really pernicious, pervasive example of what you're describing in terms of the coercive control through legal abuse. And what we were seeing in our cases here in California is that we were being served with discovery all the time for
Mhm.
civil protection orders or the civil restraining orders that are on a 3-week timetable. Respondent has one right to a continuance. And so really these are cases where you should be able to have that quick resolution within about a month and a half. But some cases being extended over a year long, with
Wow,
endless interrogatories being served, deposition notices, really intended to intimidate survivors out of seeking help, or to bankrupt
right,
individuals, right? In terms of when you talk about the expense
right.
of litigating. And so that inspired our clinic to then propose SB 741, which became effective in the law. And you're in Canada. And these are international issues, what we're talking about. And I'm giving a real specific to California here in terms of the bill numbers and such. But for folks who are following along here, to be able to have some limits, we did a 50-state survey in the United States to see, are there any discovery limitations within restraining orders, within the civil codes also, pertaining to domestic violence. And my prior two jurisdictions of having taught at Georgetown American in Seattle, so my prior jurisdictions of Washington State and Washington, D.C., were the only other jurisdictions that had any limits. And so, of course, I thought there should be limits because that's where I'd been, what I'd been experiencing
Right.
as a litigator.
Right.
And so we now have this actually in law here in California, where for discovery such as depositions, interrogatories, document requests, that has to go through the judge for judicial permission. There's a list of factors for good cause, and the least invasive method is supposed to be used. So if
Mhm.
this is something that could actually just be inquired about in court as part of testimony, then we're not going to have separate depositions.
Yeah.
So that was a big legal victory there, we think, for survivors. And I'm working on, as I noted, it's not an issue that's really bounded by geography, that this as a model, we hope, certainly across the US and beyond. And wonder the question then was given this background in terms of, the normal default to broad civil discovery rules, which are fine for contract property business disputes, but really not safe in the domestic violence context to be able to have to seek a separate protective order against discovery.
Right.
You seeing examples uh, with any of the individuals that you interviewed about discovery abuse? I noticed it wasn't specified within your 14-point scale.
Mhm.
And as I noted, it's probably just one more example of the broader phenomenon that you
Mhm.
are investigating.
Mhm. Mhm. I think this particular example hasn't come up as much as some of the broad. I think a big focus of my research has been kind of broader critiques of the system and broader critiques of you know almost every aspect of of the court process. But particular examples of discovery abuse, I think certainly many of the themes that you described overlap with some of the data in terms of prolonging a case, um, and also um, having one's kind of very personal information brought into the court process in a way that could be quite distressing. Um, so those are two examples of themes that survivors have shared that I think might actually probably manifest in cases of discovery abuse. Um, but it's a really good question, and it sounds like really important work that you're doing to try to name discovery abuse and look at how that aspect is being used, right, in order to cause this harm.
Yeah, no, and I think within that bill, SB 741, that's now codified with in California Family Code 6309. I wanted to make sure to have that statutory citation right. 6309. That I think it's the first time in California that we actually included within our statutory code a definition of litigation abuse. So this
Mhm.
idea of exactly as you're doing in your work, trying to name something to then attempt to remedy it and validate it.
Right.
Dr. Gutowski, I see we now have a number of questions in the Q&A. Um, Let me know if you'd like to just look through those, or if you want me to direct you to various ones. But we really appreciate everyone's engagement and your questions, and know that sincerely there's so much lived experience of struggling
Mhm.
to keep yourself and your children safe through family court.
Mhm.
that also are bringing people to this topic and making your work so relevant.
Thank you so much. Yes. Um, I'm just looking through them. I think if there's, if there's a particular one, I'd be happy to answer. Um,
Yeah, so I know a couple of folks were saying within the 14-point scale, the legal abuse scale,
mhm,
some of the items are about threatening to do something.
mhm. Yes.
And so whether it's threatening to withhold support or threatening to take the individual back to court. And more often, there's some comments that more often abusive partners and abusive parents just do it. They
Mhm,
just
mhm,
file, they file without notice. Whether it's the examples I'm giving of just serving endless discovery or the endless filings here that we have. And so a
Yes.
comment on that if you wish.
Absolutely. Yes. So, yeah, so we developed these items in part, in collaboration with the 23 experts who we consulted with, and it seemed like there were two aspects that were important. One was threatening and leveraging kind of power and control through the use of threats, which is a core dynamic we see in coercive control, regardless of what the context is. So even, prior to separation and prior to engaging in any kind of legal system, the use of threats really is something that is so common in coercive controlling relationships. And some researchers have written about custody blackmail. So, saying if you do not drop the restraining order, for example, or if you do not do X, Y, and Z, I'm going to go after custody of the children. So that kind of a theme was really salient in a lot of the interviews we did with survivors and also in the consultation from experts. And we didn't want to lose that. That was an important experience that I think was important to capture. But certainly, it's a really important point that a lot of times people don't threaten before they take action. They just go ahead and do it. Especially if there's very little contact between the parties, right? If they can only contact in very limited circumstances, there might not be much of an opportunity to threaten, and maybe the chance to see come face to face would be through the context of a court hearing. So certainly, I think it's a really good point. Some of the items on the measure are, threatening or actually attempting to do it. And so for that reason, we kind of named those items with that wording because the threats were really a prominent experience for some of the people who we spoke to, even if not all of them. Um, and I want to say too, I know that litigation abuse is a term commonly used. I've been using the term legal abuse because in some of the consultation we did with legal professionals and legal scholars, one of the pieces of feedback that we got was you're not just talking about litigation, right? You're also talking about using the legal system just in general as kind of a tool, of coercive control. And so I think threatening kind of gets at that. A lot of times those threats might be made outside of the context of litigation. But still, I think an important way in which coercive control can manifest in the context of these legal processes.
Oh, thank you. A couple of questions about differentiating alienation and
Mhm.
with some parents being accused of alienation when really trying to take protective measures for the children. And I
Yeah.
know as you and I were preparing for today, we talked about and you identified like context matters. And so that's part of this in terms of is a return to court for my clients' efforts to seek to protect their children. And so not simply counting the number of filings, but seeing the meaning and measure behind that. But a couple of questions, one of an individual saying they're trying to protect their children and themselves and are being accused of alienation from the abusive partner who's not at
Yeah.
all in the role of caretaker. That's very distressing. And and let me combine yeah, and differentiating between um, maybe parents who just aren't each other's forever in terms but there's not a context of domestic violence and the legal abuse that you're specifying.
Absolutely, absolutely. And that's something that I think many of us hear about a lot, that can be, a common experience for survivors to be accused of alienation. And, is a term that comes up a lot. I know in these cases and from survivors I've spoken to, um, you know, definitely in the context of developing this measure and thinking about ways in which legal abuse manifests. One of the items that we came up with that seemed to be really important for the experts that we consulted with is distorting information, or kind of lying. That was a very common theme in the qualitative research that we did. That my partner kind of comes to court and lies or misrepresents me or paints a picture, and it's a picture that makes it hard to then detect the abuse dynamic that is occurring. So I think that's a really important point because we're talking about coercive control and the importance of training and detection of this dynamic. And I think important to observe kind of the patterns in how partners who use this form of abuse can distort information in these cases and make it actually really challenging, I think, for professionals to get the picture, right, of abuse and to really understand the context and the dynamics that are occurring and the power differential that might be there.
No, thank you. Thank you for all of your insightful comments here. Um, Seeing some questions about what more can advocates and attorneys do to support folks and individuals who are going through multi-year
Yeah,
litigation. And I think of a client recently where we concluded in court and had a really positive outcome and safe protective order. And she said, okay, we never have to come back again. And I said, oh, your children are, they were of a young age. And so this is a great outcome today and will be with you for the years to come if there are additional filings. Um, but that's a sense of if it's not a one day in and out kind of an outcome and awareness of that. But what guidance do you have for advocates and attorneys who are then supporting and advocating for and really accompanying survivors through the process?
that's a really good question, and I would love to hear your thoughts on this as well. But based on some of the data that we've collected from survivors and what we've heard, it seems as though having support, having someone believe you and validate your experiences, especially when you're in a system, you're in a process, the truth is being distorted. It feels like people are not identifying the abuse experience that you had, that can be, very, very harmful on top of the trauma from the abuse. So having that validation even outside of court is something that survivors have said is really important, right? It's like, okay, my therapist or my advocate helped me identify that I'm not crazy, right? That this is my story and my perceptions of events is valid. So that can be helpful. Of course, that's not the only thing. I think, of course, my research really focuses on the psychological damage and harm of some of these processes. So seeing what services are available and what supports are available, because this is a really stressful process and very traumatic for a lot of people. Making sure that they have that connection to supports, so those are two things that come to mind. Um, uh, yeah, I'm thinking about like the social support, the belief in validation, and making sure that people have that support.
Thank you. Are you involved in any judicial training when we think about just how much your talk has resonated with our audience here and in thinking about who else needs to understand exactly what you're talking about?
Yes, I have done a little bit of judicial training, and I would love to do more. So yes, absolutely. I love to talk about this dynamic of coercive control. I think it's a really important one to understand. And certainly this is something that I think can be really helpful as well, to make sure that survivors have their abuse experiences seen and validated and also responded to appropriately so that safety and protection is really prioritized.
Yeah. Yeah, agree there. And as we think about, I'm seeing across some of the questions here, love that we're on Zoom today to be able to have a really international audience, and certainly am seeing comments that Massachusetts was not able to protect legislation yet. I'm going to say yet because sometimes it is a whole movement that's required and a multi-year education effort. But I mean, one of the issues that we faced with SB 741 on our discovery abuse was our concern in terms of what would anticipated opposition be that, well, there's a whole family law bar that might be making some money off of issuing all this discovery. And so making sure that we're actually motivated by the right purposes in terms of the focus on the legislative intent of the protective orders of protective child custody. And that seemed to be the issue with Massachusetts not yet being able to pass legislation, the abusive litigation abuse bill. I'll look for that particular bill to see, and would be happy to be part of these efforts and know that there's great folks there. Each state in the US has a statewide policy organization focused on its state's legislation on domestic violence. And so a statewide coalition to end domestic violence state by state that are really, of course, the best experts in their own state. But good to see that there's efforts to bring forward these issues that need to continue. And that's related to another question about vexatious litigation laws. And I know you're not a lawyer, Ellie.
Mhm.
You have all these credentials, and so I don't, feel free to say I'm not sure. Uh,
Mhm.
but more states do have vexatious litigation laws in terms of how if there have been a certain number of filings by an individual that are not meritorious. And so they
Mhm.
keep losing, they keep doing the same nature of filings. And so we have certainly had certain opposing parties declared vexatious litigants because it's otherwise just endless. And now they have to go to court to get permission to file. So there's still access to the courts, but you have that gatekeeper review. And a law that went into effect a little over a year ago. I guess now we're almost 2 years ago. That if you are protected by a restraining order, that to have
Mhm.
litigation filed against you, that you need the judicial permission, and there's some protections there once there's already a finding of domestic violence. So this is a question in terms of actually phrasing it as a question of have you looked into vexatious litigation laws, or is that something that you're also studying?
Mhm. Yeah, I mean, this isn't, it hasn't been a focus of my research, but it would be a really interesting, I think, focus of future research, to understand how some jurisdictions with this legislation, might be, what are the experiences of survivors in those jurisdictions as opposed to jurisdictions without this legislation? Are there cases in which legal abuse is still occurring, and is not being identified, or how kind of effective are these measures at really helping to protect survivors and families from ongoing coercive control in these processes? I think it would be a really important effort to study this and to further explore this.
Absolutely. Yeah. And I know I'm giving you some examples from California where our clinic has brought forward 12 bills in the last handful of years, one of which the governor signed today, a new one.
Congratulations, that's
Thank
awesome.
you. Thanks. And so much of what we do is to do that individual representation and to
Mhm.
look what are the gaps
Yeah.
in access to safety and access to justice, and how can we help change this for more folks? um, Gail Pincus has identified an ongoing issue that ends up being really problematic for survivors. So I'm saying we've had some positive changes. We do have coercive control in our civil definition of domestic abuse, which is not the norm across states, but we still have a lot of work to do here, certainly. And one of the areas is mediation being mandatory in some counties in California, and we primarily practice in Orange County. When we've had matters in LA County, seeing our clients be referred to go to mediation before a civil restraining order hearing where there's a presumption, if you go through the hearing or have an order issued, there's
Mhm.
a rebuttable presumption that an abusive partner does not have sole legal or physical custody. But if you go
Mhm.
to
Mhm.
mediation first, the mediator might be trying to push 50-50 and
Mhm.
trying to see, is there an agreement here that we can just enter before the judge rather than actually having the legal protections and
Mhm.
legal presumption. And so to the extent that one, I wanted to highlight that we definitely have work to do here in California. I'm sharing some examples, but also you might be actually seeing from state to state some different practices that then really
Mhm.
increase danger for folks.
Right, right, right. Absolutely. Absolutely.
We're seeing a lot of individuals just identifying how much all that you've said resonates.
Mhm.
One individual saying, I check off all those boxes, unfortunately. And so all 14 of your items, and we just our hearts go out to you and we want you to be able to have the support and safety that you deserve and need. Um, a recommendation that the appellate process also be added to future legal abuse scales, because we
Mhm.
know even when we get what is a safe and protective order out of the Superior Court level, then seeing is there a likelihood of then just trying to take this through the appellate level and continue litigation abuse, taking it higher up, and if
Mhm.
that's something that you're also looking at.
Mhm. Really, really important point, and I really appreciate that. Absolutely. Yeah.
I invite you to also just look through the questions here. I know we've
Absolutely.
wonderful,
You know,
wonderful.
there was another point that I was thinking about as you shared your example of your client earlier of having, you know, one positive outcome and then having to kind of talk about, well, you have young children and this might be a process. I know there was a question that came up earlier around what advocates and lawyers can do to support their clients. A theme that came up across some of the studies that we've done is the importance of understanding, you know, what expectations one should have, so of the process, right? So a theme that came up is really feeling not only invalidated by the process, but also just totally surprised that this, you know, that this was going to be an ongoing stressor, and that, you know, maybe kind of hopes and expectations are not met or are not attainable. So that was another thought I had actually as we were chatting, you know, in response to your comment and your description of your work with your client, that, you know, some sort of education around what this process involves and what survivors can expect from it.
Yeah, yeah, no, certainly. I had a client who we represented in getting a domestic violence restraining order who was pregnant at the time. And the questions after then the baby's birth, she was saying, should we go back to court to have the baby added? And I was like, let's see how things go, because if the abusive partner is not on the scene anymore,
Right,
otherwise, do you want to invite a paternity finding and visitation? Uh,
right.
and so the really individualized work that has to happen, uh, um, we've put here in the overall in terms of additional. So I think that that's just really important. There's not a one size fits all. There's several questions in terms of rates of individuals losing custody of their children, and there's a lot of there's some. I'll say there's some varied research on that, and some of the research really focuses on appellate cases, and I think it's really important to also look at what's happening on the Superior Court level as well. And so there's not like a one size set of instructions in terms of how to go about establishing histories of abuse, and arguing for custody, certainly. Right. And looking, and what we did put into the webinar chat just now, in addition to the MCLE form, where there's an hour of MCLE credit available for legal practitioners. A question about, I mentioned one of our clinics bills that we brought forward this past year's was about technology within cars. And so there was a question about what bill was it? And I put a link to the domestic violence bills that Governor Newsom just signed today, a whole suite of domestic violence bills. The particular one that our clinic worked on just recently was, with all the technology that's becoming increasingly available within cars, we see that as a way that stalking and abuse is being carried out, with individuals summoning a car to them that they have access to, changing the rate, changing the music within a car as my clients are driving, like all of these ways of coercive control, certainly interfering
Mhm.
with someone's well-being and their actual safety in terms of tracking them. And so
Mhm.
this is a bill that then requires the auto manufacturers to sever an abuser's access to the car and to that technology,
Mhm. Mhm.
which until this point they had refused to do or said that they were unable to do. So that we hope becomes a global model for change, because it's not an issue only specific to California, but we need the national and global work on that front as well.
Absolutely. Absolutely.
Yeah. In our last few minutes, and I know you've been able to review some of the items here. Is there any final words that you want to say in terms of just what I'm curious what you're working on right now? All of your research has been so fascinating, and you're producing so much good work on this. Um, so whether it's kind of what you have in the works right now, or anything else that you want to say to our many audience members who I think are a combination of individuals who are really living this and seeking to protect themselves and their children in family court presently, who have struggled over really the decades to do so, legal
Mhm.
practitioners, medical practitioners, therapists, scholars, students who are all tuning in today.
Yes, thank you so much. Yes, well, we do have some projects in the works around, we looked at the mental health correlates of legal abuse. We're also looking at the economic correlates. So, in some of our qualitative interviews, what's come up is that, survivors are really having to invest a lot of time and energy into these court processes, and incurring a lot of financial costs, maybe for representation, but also for taking days off of work, maybe having to take a leave from jobs. And so we've been doing some work to try to understand that as well, and to kind of show links between legal abuse and vocational outcomes, as well as financial outcomes for survivors. And so I'm just thinking about, most of my work has really focused on defining legal abuse, but also looking at mental health, the harms that are associated with it, mental health and economic. And what I'm really hoping comes from this work is that we really attend to this issue, that we learn how to better recognize coercive control in our systems, and that we modify processes so that survivors don't have to be so traumatized while going through such a stressful experience of leaving an abusive relationship, which is already a really vulnerable, difficult situation to be in.
Uh, Dr. Gutowski, thank you. Thank you so much for all of your
Much.
work here. And I think there's so much that we can each do in terms of then thinking about how your work is applicable
Yes.
to individual situations, to countywide and statewide responses. I know here in Orange County we have a family violence council, and
Mhm.
we'll strategize as legal advocates to see, are there certain issues, there are questions here about what do you do about judicial betrayal. And so is it an instance where there is an appealable issue, but also is there something that needs to be addressed by the presiding judge of family court or higher, in
Right.
terms of something that's just not a safe practice being carried out. And so to think what has to be changed through the laws, through the advocacy and support resources that we have, and beyond. Thank you. We're going to keep looking for your work and to have an open invitation for you to return anytime. And I want to make sure to note our next event is going to be presented by Dr. Ilona Yim, who's a professor here at the School of Social Ecology at UCI, who's done work and presenting on parent-child separation and health in adulthood. That's going to happen on October 30th. It'll be in person here at UCI Law School with lunch provided if folks are able to join us. And then we'll also have a remote option for individuals as well. So thank you so much for all of your work and your time and knowledge that you've shared today.
Thank you
Thanks.
so much for having me. I really appreciate it. And thank you for the important work you're doing as well.
Thank you.